Just so you know, this show is about scary stuff. So don't say I didn't warn you guys. And remember, don't be scared.
Episode 100, Thoughts on Jones v. Mississippi. War Baby here with another episode of Murderous Minors. We've reached our 100th episode, and I've shortened the lengthy conversation I had with our friend of the show, Antonio Espree, on the topic of the recent Supreme Court decision in Jones v. Mississippi. I want to thank everyone who has listened, and I want to thank Tony for sharing his thoughts on the matter from the perspective of a former juvenile lifer turned thriving university student and employee and citizen. In upcoming episodes, we'll be talking about Kipling Kinkle, known for being the Thurston High School shooter who just recently gave his first ever interview since killing his parents and two classmates at age 15 in 1998. As well as the STEM School Highland Ranch shooting in December 2019, as the second of the two perpetrators, then 16-year-old Devin Erickson, just went to trial. You know what works better than home remedies and over-the-counter acne products, which could damage your skin? Prescription treatments. That's why we're excited to partner with Apostrophe, the sponsor of this episode. Apostrophe is a prescription skincare company that offers science-backed oral and topical medications that are clinically proven to help clear acne. Apostrophe connects you with a board-certified dermatologist who will create a personalized treatment plan that is perfectly tailored to your unique skin. Simply fill out Apostrophe's online quiz about your skin goals and medical history. Then, snap a few selfies and your dermatologist will create your customized treatment plan. Apostrophe is really making it easy for me to reach my skincare goals in the most convenient way possible. Not needing to schedule an appointment or go anywhere was honestly a lifesaver. We have a special deal for our audience. Save $15 off your first visit with a board-certified dermatologist at apostrophe.com/warbaby when you use our code WARBABY. This code is only available to our listeners. To get started, just go to apostrophe.com/warbaby and click begin visit. Then use our code WARBABY at sign up and you'll get $15 off your dermatology visit. That's apostrophe.com/warbaby and use that code WARBABY to get your dermatology visit and save $15. And we thank Apostrophe for sponsoring this podcast. What did you think when you heard about Jones?
So, prior to Jones v. Mississippi, the courts did something I call historical, also exceptional, is the courts separated adults from juveniles. Also, it brought about the evolution of the Eighth Amendment on cruel and unusual punishment and what that would look like. And so these cases were cases that with the vision and the hopes of the justices were to push society to see our young people as not just disposable human beings, but to see our young people within the same framework as a minor and with the hopes of being able to be rehabilitated, to be reformed. What that looked like in terms of incarceration, the length of sentence that they would serve, how they would serve their time in incarceration. The courts didn't look at that. They looked at how if someone was at the age of 16 or 17 or maybe even in some cases 18 years of age, who would enter the Department of Corrections, and spend maybe 20, 25 years or 30 years of their lives, would they still hold on to the same mentality that they had when they were at that young age? As a result of that, the courts was able to foresee that and support not just the idea, but support, as you talked about, the science that was behind the length of time that it would take for a child to mature, to develop a different set of characteristics, different attitude, different thought patterns, et cetera, et cetera. And were they able to identify with, through maturity, being an adult, taking responsibility, being remorseful, all of the things that someone as an adult would do through civil behavior? Yes, that's possible. Yes. Young people throughout incarceration can achieve that. Young people have achieved that. I am a witness. I myself have achieved that. There's countless others that have achieved that. You know, one of the things that Justice Sotomayor spoke about that Justice Kavanaugh did not speak to was the fact that Jones, within a short time, I won't say short time, 10 years is a long time, from entering the system, Jones was able to achieve his GED. He was able to not have any bad run-ins or occurrences with staff or his other peers. He was able to engage in the ministry at the prison and become a role model. Within the 10 years prior to going back to court, he was able to accomplish and achieve. He was able to learn to develop a mind state that took responsibility for his actions, develop a mind state to become remorseful. He was able to develop the words, a character that was responsible, that shared not only compassion, but empathy around what his actions had did. And also the very significance of understanding, as Justice Sotomayor pointed out to, that was his upbringing. What was Jones' upbringing like? The abuse that he went through, the physical abuse, the mental abuse, the emotional abuse that he suffered, those triggers, the medications that he was on. There's a history attached to that. And being in prison, and for him to develop, for him to grow, for him to mature, these are the things that the judges in the Miller case, in the Roper versus Simmons case, in the Florida versus Graham case, in the Montgomery case, they all foreseen and saw and understood why juveniles should be given an opportunity and a chance at parole. Not to say that there should not be any accountability or any responsibility attached to the behavior that was demonstrated to that child, but to say that how important it is that we revisit this child's life at some point to see if that child's now grown into an adult still maintains a certain state of mind or certain behavior, or what kind of being has he or she developed into. And that's very significant for not just those cases that I talked about, but that's significance in terms of a guideline for judges in courtrooms to be able to say, in reviewing a case that's before them of someone who's committed a crime when they were a child, to say, based upon what you have demonstrated in terms of maturity and discipline and conduct throughout the course of your incarceration, would be the means for me being him or her as a judge, giving him or her the opportunity to be resentenced and to be paroled.
I know, and you would think that would be the case.
Yes.
You know, and you talk about everything that Brett Jones accomplished in that 10 years. And we have to remember that he had a life without parole sentence. Most of the time, people with life without parole sentences aren't even given the opportunity to have education, to participate in programs. So he did these things with everything against him. And his childhood, you know, so sad and traumatic, but I just think that's kind of becoming more of a norm. That doesn't have the same effect that it should have on people anymore. Children still grow up in less than ideal circumstances. And of course, not every one of them even becomes, involved in criminal activity of any kind, much less become a killer or a murderer or something like that. But how does one become rehabilitated?
And that's an excellent question. And just before I give way to conversation to it, I just want to point to how important it is to stress that any violent crime, especially murder, that's committed by someone that is under the age of 21 or 18, there is and should be a connection to accountability and responsibility. No one deserves to die. No one deserves to be murdered. No one deserves to be tortured. No one deserves to have their lives put to an end. So that I just want to be clear about that. There has to be an attachment of accountability and responsibility to that. When we look at rehabilitation, that's why rehabilitation is so important. Rehabilitation provides the path for someone who's sentenced to be able to learn to develop and discover the components of remorse, empathy, accountability,
respect for human life,
responsibility. Yes, respect for human life. Those essential things. That's a part of rehabilitation and part of reform that helps the child, he or she who committed that crime at a young age, to identify with what they did, to own it, to be able to develop the words to say they're sorry, to say this is what they done or participated in, or what they understand, how they understand why they are guilty of such act. How do he or she begin to live with what they've done and to learn to make usefulness of their life? Because it's a debt that they owe, not just to themselves, but to society as well. Is it a debt that they can pay off? Some may say no. Some may agree and say yes. What that debt looks like in terms of paying off depends upon what he or she has learned while in confinement, while incarcerated. And when we talk about rehabilitation, we also talk about what is being offered. Is it being offered? Programs, classes, psychological therapy, counseling, group counseling, anger management. Are these programs being offered? If they're not being offered, why they're not being offered? Is it because that the person is sentenced to a natural life without parole sentence and the state feels that this particular person is not worthy?
Right. What's the point
of the program? Exactly. What's the point? And so when you have that type of attitude, then imagine someone does 10, 15 years with no counseling, that cannot make the connection. And here's these cases that's coming out now. The Miller versus Alabama case, the Montgomery case, and they have an opportunity to have their cases reviewed, but they were not able to participate in any program to help them to rehabilitate themselves. So a life that's incarcerated, that's young, does not have to be wasted. It can be invested into. This is not about reversing a decision that a judge has made or judges on appellate review have not given any review to. This is about constitutionality. This is about saying, from a constitutional rights perspective, this person deserves this. That's what it's about. And when you don't do that, it's almost like an act of saying, because you're responsible for this phenomenon, this is the retaliation we'll take, and not give you what everyone else is getting. And that's not what the justice system should be based off of. It should afford the protections and liberties that it was created to do. And of course, judges should be, by oath, they should uphold that. And it's sad that there are still, as even Justice Sotomayor have laid out, still over 1,500 juveniles still incarcerated that should have been given resentences before the Jones case has came down. But we have prosecutors and judges who feel and has felt as though the courts in Miller or the courts in Montgomery, in those decisions, they were not clear enough. And the justice, I believe it was Justice Kennedy, he long said that what they wouldn't do is they would not intervene in the sovereignty of the state by telling the state what to do. Because the states have a job, meaning legislators are supposed to, when given such a change of precedent of the law, they're supposed to develop those laws in which their states follow or flow within those new changes. But it becomes political instead of, well, here's how it should be done. So not intervening was the right thing to do. From a state constitution perspective, states have yet to change their constitutional 8th Amendment to fit what the federal Constitution 8th Amendment on cruel and unusual punishment looks like. And that's sad. And now with this new case, Jones versus Mississippi, you don't have an avenue. You don't have an avenue in which you can go up to the higher courts with, because of their views and opinions that has nothing to do with the 8th Amendment on cruel and unusual punishment. It has everything to do with undermining the Miller case and the Montgomery case and continuing to afford judges and prosecutors the power to strip from young people the ability to be able to have their cases reviewed if they can show. And in most cases, I'm advocating and saying that they can really show that they have reformed and rehabilitated themselves under circumstances that are not normal. Remember, this is prison. And so it's like the Miller and the Montgomery, they were like someone playing a lottery. I don't want to minimize it, but the analogy that I'm using is someone going to play the lottery in hopes of winning. And with the rulings that came behind their name in the cases, they should have been the first.
They should have been first. It should not have taken Miller 4 years to find out what his resentence, was going to be, what his term was going to be. Do you think life without parole or possible death penalty sentences are a deterrent to crime?
I think that for a juvenile to receive a natural life in prison without the possibility of parole is a death sentence. And when that sentence is handed down, it is a sentence that's saying, even though a state may not have enacted the actual death penalty, it is a state that is saying that you are hereby sentenced to death. Should it exist in cases, when we look at what type of juvenile is a juvenile that cannot be rehabilitated, what type of juvenile exists that cannot outgrow a particular characteristic, a particular mindset, a particular conduct. When we look at these things as adults, as a civilized society, as a society that bases a lot of its rims around science and data, research, etc. When we look at that, to say that such a juvenile like that exists, then as adults, you're saying that you can't come up with a solution or resolution to be able to help this child to be able to reach the stages of development that they need to, which is called maturity. One of the things that Justice Sotomayor spoke about was
in her scathing dissent.
Yes. She said the court held that the Eighth Amendment forbids sentencing children to death because capital punishment must be limited to those offenders whose extreme culpability makes them the most deserving of execution. Juvenile offenders cannot, with reliability, be classified among the worst offenders for several reasons. First, as any parent knows, and this goes to what you were saying earlier, as the scientific and sociological studies have confirmed, juveniles are less mature and responsible than adults. Second, juveniles are more vulnerable or susceptible to negative influences and outside pressures and have less control over their own environment. Finally, the character of a juvenile is more transitory than that of an adult. As individuals mature, the impetuousness and recklessness that may dominate in younger years can subside. One of the things that should be the guidance for judges is taking that time to see the question should be, what all have you accomplished while in prison? I want to know you for who you are or have become now. These are the questions that judges should be asking themselves and measuring him or her that's there to be resentenced. Because you want to prove about brain science. You want to prove and say, if this is so, according to Miller, according to Montgomery, according to Florida versus Graham, according to Roper versus Simmons, if this is true, let me see how immature you were then versus how mature you are now. Has your maturity demonstrated true growth and development throughout your course of incarceration? Let me see, show me through your brain, based upon what you were able to do and achieve, does this science add up? One of the things that Justice Sotomayor talked about was hope, because it is important for judges and society to understand that these are the premises in which we're looking for that juvenile to return back to society and be that better person, based upon the hope that while they were incarcerated, he or she was able to demonstrate the growth and development necessary, the maturity necessary to get to the point where they are ready to return back out here to society and be a productive citizen. And so these are the things that were very, very necessary for Justice Sotomayor to illustrate. If no judge has hope, if people in society doesn't have hope and only see that a child has, and I'm not taking away.
Right. We're just speaking in a general sense.
Yes. I would never want to take away from any person or persons from the pain or the hurt that they feel or have felt or were left with behind the act or actions. Not just myself, but every juvenile who has committed a crime, violent or non-violent, is attached to forever. It's a forever debt that must be paid off. That is going to be paid off based upon the actions that you bring back to society that demonstrates a respect, as you talked about, for human lives, for property, for others, for everything. I remember when Miller came out, and I was in Michigan, there was this civil rights attorney, Deborah LaBelle, who was advocating strong for us. She had to educate not just other attorneys, but had to educate professors as well, She had to educate prosecutors. She had to educate judges. She had to educate people to help them understand what was going to take place, what was taking place, why it was taking place, because people had not come in contact with this content before.
It's contrary to everything that we base things on. Logically, it makes complete and total sense.
Yeah, but it's not like lawmakers are not parents. So in what Justice Kavanaugh said, he said the state responds that permanent incorrigibility is not an eligibility criterion akin to sanity or a lack of intellectual disability. We agree with the state. Now, the federal courts is dealing with the constitutionality of an issue. The state courts are not dealing with the constitutionality of issues. They're dealing with the procedural, the sentence in itself. So for Justice Kavanaugh to look at a case through the lenses of a state justice and concur, that shows right there that Justice Kavanaugh was not looking at or providing the federal protections around liberty to this particular case, to the Jones versus Mississippi case. Had Justice Kavanaugh provided the liberties constitutionally to the Jones versus Mississippi case, he would have been in conjunction with the Miller case and the Montgomery case. But Justice Kavanaugh is looking through the lenses of the Jones versus Mississippi case and saying
of his old job,
and saying that there could be situations where a judge may be faced with a juvenile who's committed an act. This kid is sent off to serve this sentence. 20 years later, maybe it's the same judge or not. Maybe it's a different judge. It's now before a judge. Nowhere can be proven that this kid or this now adult is the same person they were 20 plus years ago. And so now what happens is the judge can say, you'll never change. You committed that crime and you deserve to be in there for the rest of your life, regardless of what you have accomplished and achieved. And Justice Kavanaugh supports that when he says that the states respond that permanent incorrigibility is not an eligibility criterion akin to sanity or a lack of intellectual disability. We agree with the state. And so for you to be in concurrent with this decision, you're not affording the federal constitution to this particular juvenile upon being able to be resentenced or have a resentencing hearing. The opinion that Justice Kavanaugh came out with and how he supports and dissects different parts and pieces of Miller and Montgomery, how he supports this idea that juveniles cannot change. Their crime alone demonstrates the worstest of reflections against humanity. To have such an idea and to hold such an idea against a juvenile for the rest of their lives.
And remember, not have to be able to prove it.
Right.
Because you can't.
Yeah. Yeah. It's not something that we as human beings want to be governed by. You don't want to be governed by a decision that can easily strip you away from your rights and liberties or minimize them to a certain degree where you would almost feel as though you're not deserving of it.
We went on for hours with this discussion, but I'll leave it right there for now. And you'll get to glimpse a bit of the recording in action in that future documentary film that I mentioned before. As always, thanks for listening. Be back soon with a new episode, so until then, lovelies, Don't be scared.